Hi everybody, this video is about the polity related question those came in the 2022 UPSC Prelims General Studies Paper 1. Now you know that day by day the UPSC Prelims becoming big hurdle for many of the UPSC aspirants. Most of the questions that come nowadays not usually found directly from the standard materials. So here we need to apply some logical and rational thought process so that we can approach the question in the right way and able to solve correctly. The main idea of this video is to give you my perspective while looking at the question. I have set A with me. Let's assume that I don't know any answer with 100% accuracy and then solve. Okay, let's directly move forward to the question number 11. Now in this question they are talking about contempt of court. So you must have come across this contempt of court term in newspaper and daily current affairs. And so it's very obvious to think that who else will punish if the Supreme Court and High Court don't have the power to do that. So the statement 2, which is saying that Supreme Court and High Court punishes for its contempt of court, so it's very obvious to have that. So I don't have any problem to take that option 2 is correct, even if I consider that I do not know this statement exactly, but it looks quite obvious. Now if I take option 2, statement 2 as correct one, then I can very easily exclude the option C and option D. Now I am left with option A and B, where I can find that their option both the option having the statement 1. Then statement 1 is the correct one, which says that Contempt of Court Act was passed in 1971. Now if an act to pass, who else to do that? The Parliament, which is the law-making authority of this country. Which in turn says that statement 4 is also correct because the Parliament is vested with the power to make the contempt of court. So hereby taking that option 1 is correct, we can very easily say that option 4 is also correct, even if we do not know. So the option B is the correct one. Now the question 12. Now we can't solve this question from the conventional source like Lakshmikant or NCERT. So it's better to assume that you don't know the answer directly. Look at the second statement, where it says Bar Council have the power to lay down the rules related to the legal education and recognition of the law colleges. We all have heard about Bar Council, and which we know that which gives license and legal practitioners and also look after the professional conduct and etiquette, overall professionalism, and exercise disciplinary jurisdiction over the bar. So this statement is looking quite reasonable, so I can take option 2 as correct ones. But if I look at the option 1, where it is saying that the government law officers and legal firms are recognized as advocates, let's consider that I do not know about this statement. Are they considered as advocate? Not. But the corporate lawyers and patent attorneys are excluded from recognition as the advocates. It could be okay because the corporate lawyers and the patent attorneys are not supposed to practice each and every day in the law courts. So this second part looks quite logical and that could be right. But if the first part is also right, then the entirety of this statement will be right. Now we know that law firms are supposed to give advice and on the legal rights and responsibilities, not like the practicing legal professionals, so who appear in the court of law for practice. So which in turn says that legal firms are not supposed to be recognized as advocates. And if you can remember, or if you know that few years back Allahabad High Court said that the fulfillment that the full-time salaried law officers cannot be considered as the advocate, even if they occasionally appear in the court during such employment. So the option 1 is not correct. The first part of the option was incorrect. So hence the answer is B. Now this is an easy question. Okay, you can very easily solve this question just from the Lakshmikant, but consider that you do not or you cannot remember the proper provisions of the Constitution Amendment Bill. Now, then also you can solve this question just by logical thinking. Okay, we know that the constitutional amendment bills, like the amending the Constitution of India, is the process of making changes to the nation's fundamental law or the supreme law. So these bills are of ordinary are not ordinary bills, so they are supposed to be the modification of utmost need. Now, our constitution has many federal provisions. Now, the changes to it may also lead to the changes in the federal provisions too. So here, the states and the center must have say in it. So that's why it is very obvious to consider that the Rajya Sabha and the Lok Sabha both must have the say in its process. So here that statement 3, which says that Lok Sabha and Rajya Sabha both needs the special majority for the constitutional bill amendment bill to pass, and there is no joint sitting. So here the statement 3 seems right. Now we know that the president has the power of veto, and which is applied for the bill which is houses to him, presented to him or her. But this process may lead to the lag of or even like for the reconsideration. If the president sends is for the reconsideration, then also the time lag might happen. But as I said, the constitutional amendment bills are supposed to be the ones which are utmost need. So here it is very much obvious to think that it will be obligatory for the president to give his or her assent on the constitution amendment bill. So here that statement 2 looks right, and we know that only money bill needs the president's prior permission to introduced in the parliament. So which is not for the case in the constitution amendment bill. So in this scenario, that statement 1 is not right. So statement 1 is incorrect. So if you know statement 1 is incorrect, then you can very easily eliminate all other options. But I was like supposed to make you think that if you do not know the answer of you, or if you cannot recall it properly, how can you think it? So that's why. Now let's move to the next question, which is question number 14. This is also a very easy one, and where like you can see that it says statement 1 that there are 4 ranks in ministers, but we know that no, there are not 4 ranks, there are actually 3 ranks. The state of ministers with independent charge and the state of ministers, they are not separate. Actually in constitution they are not separate. There are ministers who are independent charge, having independent charge, but in constitution there are only like the cabinet ministers, under it the minister of states, and below it the deputy ministers. So statement 1 stands wrong. Now the statement 2, which is very like well known, or like you can find it in Lakshmikant, that yes, there is limit for the maximum strength of the council of ministers, which is up to the 15% of the strength of the Lok Sabha. So statement 2 is right, and now the option B is the correct one. Now let's move to the question 15. This is also very easy question, like the exclusive power of Lok Sabha. Now these provisions, these exclusive powers are all given directly in the Lakshmikant, but let's consider in this case also you cannot recall it properly. Then what you can do, let's just think about it. Like the Lok Sabha, like the Council of Ministers is responsible to the Lok Sabha, and so the Lok Sabha is the only authority, or like the only house which can pass the no confidence motion. So like in that aspect the statement 2 stands right, which is the exclusive power of that Lok Sabha to pass no confidence motion, because the Council of Ministers is only responsible to it. So if the statement 2 is right, then the C and D eliminated. Now statement 1, to ratify the declaration of emergency. Now we know that there are three types of emergency, and as we know that when the emergency provisions applied, the Indian polity shifts from the federal structure to the unitary structure. Now just think, for this shift you need the consent of the states, and the Rajya Sabha in the parliament, the upper house actually represents the state, so you need ratification from them. So it's not the exclusive power of the Lok Sabha to ratify or to declare the emergency. So the option 1 is, so statement 1 is wrong, then the option B is the correct one. Okay. Now anti-defection law. Now this thing comes each and every day in news, and this question is not different, and the statement are this type of statement you usually see in your everyday news articles. So it is not so difficult to solve this question. Now statement 2 is correct. Now how can I say that statement 2 is correct? Because you used to see this argument, or like read this type of argument where people are arguing that there should be the time limit for the presiding officer to decide over the defection case. So here the statement 2 is right. There is no upper limit, there is no time frame for the presiding officer to decide on the defection case. Now but the statement 1 is wrong, because the nominated member can join a political party. So it's not they cannot join a political party within 6 months. They can join a political party within 6 months, but not after it. So then statement 1 is wrong, and hence the option B is the correct one. Now if you read Lakshmikant carefully, you can solve this question also. But again, if you can't recall it properly, how can you solve it? So we know that Attorney General is the law officer of the government, and it can also participate in parliamentary meetings. But the Solicitor General is one for assisting him. So he is not supposed to get that privilege what the Attorney General gets. So we can take that option 1 as incorrect. Okay, option 1 as incorrect. Now it looks quite obvious that Attorney General with which resigns if the government appoint it also resigns. But here the catch is it according to the Constitution? Because it is saying according to the Constitution. Just think for a while, the Constitution is only comprises of fundamental and essential provisions. So the resignation of the Attorney General, and even in these specific circumstances, is not necessarily in the Constitution, so which is not so obvious. Like it doesn't look adequate to have that in the Constitution. So statement 2 is also incorrect. Now we came in the result, the option D, there's neither 1 or 2. Now let's try to solve this question, considering that you can't even recall what the mandamus mean. Like though it means that we command, but leave that thing. So now statement 2, which says that it cannot be against a government company, which is not correct, as we know that writs are enabling provisions to get the fundamental rights from the authority, and here for the government authority comes in the first place. So this statement is wrong. So if the statement 2 is wrong, we can eliminate it, like this will be wrong, this will be wrong, and this is wrong, also wrong. So we are left with options C, that is 1 and 3 only. You can also check, like mandamus is not lie against a private organization unless it is entrusted with public duty. Yes, it looks quite logical, because if something is supposed to do public duty, in that case that the rights issues comes. And for the statement 3, so any public minded person can be a petitioner to move court to obtain the wreath of quo warranto. We know that quo warranto follow not follow the locus standi, so that's why, like any person can move to the court for anyone for the violation of the fundamental rights. Now the last question for this video is, now this question 20, now when this type of question comes, those are too lengthy, so I do it in a very different way. So I first read the statement which is given in the given list number of time in the option. So you can see that option, the statement 1 is in 2 times, like except option 3, statement 3, every other statements are given 2. So okay, so take option 1 first. Like, as per the rules and procedure conduct of business in Lok Sabha, the election of the deputy speaker shall be held on such date as by the speaker may fix. As the speaker is the presiding officer of that house, so it looks quite reasonable that the speaker will fix the date for the appointment of the deputy speaker. So the statement 1 looks quite okay. So if the statement is 1 right, then the C and D is eliminated. Now both the option A and B contain C, so C must be the right one. So look at the 2. There is a mandatory provision that the election of a candidate as deputy speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. Like this type of provisions, it's not mandatory. Like you can think so, like not so many things is mandatory in the parliamentary provisions. Mostly many things in the parliamentary provisions are the usual practices or the conventions. So when the term mandatory or like any extreme term comes in the parliamentary proceedings related, then you can think or you can take it as wrong. I hope in most of the cases, like 90 to 95 cases, it will go right. So I am also taking here this statement is wrong. So if I take statement 2 is the wrong, then we came up at the statement so answer is A, 1 and 3. So 3 is the right one. Now let's check 4. 4 must be the wrong if the answer is A. Like the well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker and the duly seconded by the prime minister. Now here the appointment of the deputy speaker is that the motion moved by the, it's not looks okay. Here the prime minister's role in this case. So statement 1 is correct.